This week in Utah politics, a Salt Lake Tribune investigation found Utah Governor Spencer Cox's office was made aware of possible misconduct by the head of Utah's National Guard 2 years ago, but they did not investigate until the Army substantiated those allegations. Shockwaves are still reverberating throughout Utah's political landscape after the Utah Supreme Court ruled the legislature overstepped their authority when they gutted the independent redistricting commission that was approved by voters in 2018. What's next? We'll discuss. Utah politicos react to the attempted assassination of former President Donald Trump, and Republican gubernatorial candidate Phil Lyman, who lost the primary election, is heading to court to keep his election loss and reality at bay. Joining me now on the podcast is my colleague from the Salt Lake Tribune newsroom, Emily Anderson Stern. Thank you so much for spending time. I know I can be a bit much sometimes, but at least it's on a podcast, so I can force you to come on here and talk to me from time to time.
Yeah, I'm happy to join, and it'll be fun to have more of these conversations as you keep building out this podcast. Yeah,
let's get into the big political stories of the week. And wow, you have an absolute bombshell of a story that is in the Tribune about Governor Spencer Cox and the head of the Utah National Guard. And tell us about that story. Talk a little about that story, and then I want to talk about the process you went through to get these records that were at the heart of the story, because it really is an amazing piece of investigative work on your part.
Well, thank you. This takes us back to about a year ago, when everyone remembers that President Joe Biden visited here. There are pictures of the head of the Utah National Guard greeting him. Shortly after, we find out from the Army that they'd been investigating him for 2 years, and that they'd concluded that investigation with substantiated finding. At the time, we had no idea what that substantiated finding was, but there are sources who told USA Today, Army Times, that the substantiated finding was sexual misconduct. The governor's office puts Major General Michael Turley on administrative leave, and then quickly after, unceremoniously replaces him with who's now the head of the National Guard, Major General Daniel Boyack. So the investigation starts there. I had an assist here from a former Army Times reporter, Davis Winke. He let me know, hey, you may want to look a little bit more into what the governor may have known ahead of time. So we started digging for records then, and it's just led us through a chain of records that, what you'll see in this story essentially shows that back when the governor's office received the first allegations against General Turley, the governor had a conversation with Turley and called off an investigation that was launched, instead asking the general to survey his troops about the command climate there. And then they talked about the survey results, and Governor Cox gave him directions for how to improve his leadership. But, a spokesperson for Cox has never been able to provide details as to what those recommendations were, saying it was a private conversation and they have no idea what was talked about. And the investigation ended there after Cox's office received allegations that essentially Turley had created what anonymous whistleblowers called a dangerous environment in the Guards, saying he made violent threats, he mishandled sexual misconduct cases, just a long list of allegations, essentially saying he wasn't, living up to military regulations and fulfilling his role.
That is astonishing that there were these allegations of sexual misconduct against the head of the Utah National Guard, and the governor decided not to investigate after speaking with the person who these allegations were made against, basically saying we're good. And then 2 years later, the Army substantiated those allegations. Truly, that is a shocking chain of events there.
Well, I will say the Army investigation, we don't have their final report.
Sure,
We
because
submitted a
you
FOIA
filed a
request.
FOIA request. Yeah, a FOIA request.
Right.
Sorry.
And they haven't fulfilled that. And, the governor's office has repeatedly told us they haven't shared that information with them either. But, from what we've heard with people familiar with the investigation, from representatives of General Turley who've spoken in public hearings, the substantiated finding was around General Turley's individual sexual misconduct. Letters that we obtained that went to the governor's office, a lot of those allegations focused on his command style, his leadership style. And the Army, so there were three separate investigations, we'll say, that the governor's office opened into General Turley. The first one was that one in 2021 that the governor's office called off after his conversation with General Turley. The second one was in 2022. And that one was opened after a reporter from Army Times, Davis Winke, reached out to the governor's office and said, hey, the Army is investigating the head of your National Guard. Like, do you have any comment or thought about that? And the governor's office was like, oh, the Army is investigating him for allegations against him. Maybe we better look back into these letters that we got a year ago. And so what happens is the head of human resources, the human resources agency for the state, starts investigating some of it. And from the records we obtained, that investigation entirely centered around another interview with General Turley. And in that interview, General Turley told the investigator that what the Army was looking into was his alleged sexual misconduct, which he declined to share any additional details about. It was looking into his command style, which he had described to the investigator as, quote, yelling at people, and also alleged misuse of a federal vehicle. And he denied that, saying that he drives a state vehicle. So that's, what they looked into. And then after the Army concluded its investigation with substantiated finding, the governor's office reopens its investigation and actually starts interviewing top leadership. They interviewed several people within the Utah National Guard, and the majority of the allegations in that initial letter they received were substantiated through those interviews.
That's just an amazing piece of work. And you fought with Governor Cox's office for quite a while to get access to these records. They did not want to hand them over to you. Can you talk about how long that process took, and just sort of give us an overview of how you eventually got your hands on the documents that are make up the biggest part of this story, which is really terrific?
So, shortly after we found out about these investigations, that shortly after General Turley was dismissed or relieved of command, submitted records requests to the governor's office asking for complaints against Turley, and then also submitted requests to the Division of Human Resource Management asking for any investigative records into Turley. We got some of those. Early on, we got some of those complaints against Turley from the governor's office, and that's that initial email received in 2021 and another anonymous email received by Constituent Services in 2021. And the Division of Human Resource Management, they denied the request, saying, yeah, we've got investigative records, but those are the property of the governor's office because he asked us to do the investigation. So I resubmit that request to the governor's office asking for these records. I'm again denied. Then you start an appeal with the State Records Committee, and the request to the governor's office was in November. We've been going through this appeal, going through mediation with the governor's office. Eventually, what happened is, we came to an agreement with the governor's office that they would release the records, but they wanted an order from the State Records Committee to do so. So we got the order. That order was officially entered, just over a week ago, and now we have these records.
Well, just an incredible piece of work, and I really would encourage everyone to read that on sltrib.com. But that's not the only story. I mean, I could spend a long time chewing over this because the ramifications for this and what it means are really remarkable. But there's other stories going on that we just want to touch on in our initial podcast. Let's talk a little bit about the Utah Supreme Court's redistricting opinion. I know that came out last week, and we're going to be speaking with Ben Phillips from the Campaign Legal Center. He's one of the plaintiffs in the case. We'll be speaking with him coming up on the podcast. But you also covered that issue from the Utah Supreme Court, that they took the lawsuit said that Utah's congressional maps were an illegal gerrymander. And the Utah Supreme Court, while they didn't determine that, they did determine that the legislature overstepped its bounds when they gutted the Independent Redistricting Commission, which was approved by voters in 2018. Give us a little bit of the Cliff's Notes of how you understand how this all came down.
So, I think one of the most interesting parts of the decision it was penned by Justice Paige Peterson, and it was a unanimous decision. All of the justices agreed, and mostly what it centers around is Utah voters' right, essentially, to change the way they're governed in the state by ballot initiative. So, her quote that I found just fascinating was, "We hold that when Utahns exercise their right to reform the government through a citizen initiative, their exercise of these rights is protected from government infringement. This means that government reform initiatives are constitutionally protected from unfettered legislative amendment, repeal, or replacement." So, essentially, the legislature, when they receive these ballot initiatives to implement, as they're implementing them into state law, the Supreme Court said they can make minor adjustments, right, to make them fit in with code, but they can't substantively change what the voters' will is in passing that ballot initiative. And so,
right, and that's what lawmakers did in 2018. There were 3 initiatives that made it on the ballot: the independent redistricting, known as Better Boundaries. There was one legalizing medical cannabis, and then there was one expanding Medicaid. And the legislature stepped in each and every one of those and changed them substantially, altering what the voters had passed. And the Supreme Court said that they can't do that. So, what does this decision mean? And the way that I understand it is it goes back down to a lower court, and they're going to determine whether the legislature made reasonable changes to the redistricting commission. What this decision doesn't mean, as I understand it, is that we're not going to redraw maps just yet. Is that how you take it?
Right. And, and the Supreme Court said it may take further action, but it kind of depends on how the district court handles this question, and if the Supreme Court again needs to step in and give directions to the legislature around the handling of this ballot initiative. We really don't know if this might impact those other 2 ballot initiatives you mentioned. There are some questions around how far-reaching this decision is, whether it impacts all ballot initiatives, whether it's focused on ballot initiatives that reform the government, like as far as elections. So there's still some questions there, and we'll likely see some other cases that will help answer those. But we'll also see how the legislature might act this upcoming session.
Yeah, and speaking of that, and that's a great segue into the part that I want to talk about next. The reaction from legislative leaders when this came down was remarkable, with I guess the word I want to use for ferocity with which they reacted. They did not like this at all, calling it one of the worst decisions in Utah Supreme Court history because it directly challenges their authority. It directly challenges what the legislature can and cannot do. And for years, I use this phrase, they've been an imperial legislature. And by that I mean this. They have been accruing more power unto themselves over the past few years. If you remember, right after the COVID pandemic, they passed laws saying that there could no longer be a mask mandate or there could no longer be a school lockdown. The only way that could happen is if the governor, the Speaker of the House, and the Senate President, 2 of those 3 agreed. Well, you have to wonder why those 2 are in the decision-making chain in the first place, because as I pointed out when they passed this bill, the Speaker of the House, his district is like, 20,000 people, and the Senate is a little bit larger, while the governor is statewide. So, they've been accruing more power unto themselves over the past few years, and when they get some of that taken away, they really were upset about that.
Yeah, and that's, a theme that we've also seen with their legislating around ballot initiatives. They're in the last several years, since those three 2018 ballot initiatives that lawmakers really didn't like too much, you've seen a number of ways in which they've essentially made it harder to bring and pass ballot initiatives. And, some of the reactions on social media to this decision really hinted that we'll probably see more of that this upcoming session. I thought, Representative Jordan Tusher, who has legislated around ballot initiatives in the past, made quite a remarkable statement. He, said that essentially the legislature needs to act around the power that ballot initiatives have. The quote is, "I'm afraid if something isn't done to mitigate the consequences of this decision, Utah will be a shell of its former self." So what mitigating the consequences of this decision means, unclear, but we could see that this next session.
Yeah, just speaking to that, some of the changes they've done in the past few years, they've made it harder to collect signatures because they've changed the way that signature gatherers are paid. You can no longer pay them by the signature; it has to be by the hour. I don't know if that's going to be challenged in court or not, but that makes it very hard to collect enough signatures to get on the ballot. It's already an extremely high threshold where you have to hit certain signature numbers, not only statewide, but in 26 of 29 counties. They've really put a lot of barriers in place. This last session, they attempted to change the requirements for any ballot initiative that raised taxes. Instead of a simple majority, it would need to get 60%. They abandoned that because there's a constitutional amendment that would have to go along with that. But they really do not like the idea of citizens getting involved in the lawmaking process. They think that should be theirs and theirs alone. And we'll watch this issue as it goes forward. We'll be going back to court, the lower court, to hear arguments on this sometime soon, and we'll bring you all that coverage when it happens. A couple of other things quickly as we discussed today. There was the attempted assassination of former President Donald Trump over the weekend. A really shocking situation. I remember I was watching TV, and when it happened, I immediately called one of our editors, and I'm like, Trump got shot, Trump got shot. And that's when the coverage kicked into it. But I was struck by reactions from some elected officials here in Utah on social media, particularly the ones from Senator Mike Lee and Representative Burgess Owens. Mike Lee came right out of the gate and said that in order to start the healing in this country from what is a terrible, terrible situation, that all the federal charges against Donald Trump should be dropped. That would help the country heal, which is kind of farcical on its face, but you gotta, I guess, shoot your shot, right? And then Burgess Owens immediately came out of the gate blaming Democrats, and I think it's just indicative of our social media culture where everybody has to have a hot take immediately.
Yeah, and it's almost become like a badge of honor for politicians, some of the local Republican politicians specifically, to be the first one to have the hottest take, right? To get the most likes and reposts. And I will say, there are it does get them a lot of attention. We get a lot of reactions to those. We received a lot of letters to the editor about the things that Mike Lee said.
It's that big dopamine hit. I'm not asking you to comment any further. I just think it was remarkable to note that. Phil Lyman is still trying to deny his election loss. I'll wrap that up a little bit later in the pod. We're recording this right as a couple of things are happening. He has an appeal at the State Records Committee, and then he's also got a court hearing this afternoon. I'll be covering both of those, and I'll wrap those up a little bit later in the pod. But the last thing I want to ask you about, Emily, this is our first chance to talk about the primary election results that just happened in June. A couple of things is that struck out to me. I was really intrigued by just how hard former House Speaker Brad Wilson flopped in his effort to win a seat in the U.S. Senate, to succeed Mitt Romney. He spent over $4 million, $3 million of his own money. I think it was $4.6 million, and he got 53,000 votes, which works out to about $87 per vote. That was a huge flop. And I was also surprised by how close Phil Lyman came to Governor Cox. We know that there's some dissatisfaction among members of his own party, among the Republican Party for Governor Cox. There's a lot of dissatisfaction there. But I didn't realize it was that widespread, because Lyman came closer than I expected to Cox, and I think that I'm not sure what message it sends, but it is remarkable.
Well, and that's actually one I was going to point out too, because you saw different, as far as polling before the race, you saw some polls saying that Governor Cox was going to have a much bigger lead in the race, while some polls put that smaller, closer to where it was. And it was interesting, and, it's really unclear where the dissatisfaction lies. You see some people on social media who maybe were going both ways, right? For different ways, different reasons they didn't like Governor Cox. Whether that's they didn't feel he was far enough to the right, or because they feel like, they expected him to be one way and he was another when he got into office.
Yeah.
So there's a lot of questions there.
It's quite hard to put a thumb on exactly where that discontent came from, but we've seen it for a number of years, and perhaps it was a lot of the COVID stuff, because, the first Republican state convention after he was elected, he was booed by delegates, and then he didn't show up. That was in 2021. In 2022, I don't think he showed up to that one. I know he didn't show up to 2023. He did show up in 2024, this year, where again he was booed and lost handily among the delegate votes. So that's going to be a result that we can just parse over for a number of years. John Curtis, a number of months, although we may be writing about it 4 years. Who knows? John Curtis won the Republican primary for U.S. Senate. He's the odds-on favorite there to succeed Mitt Romney. And then the other one I want to talk about briefly is the Congressional District 2 race between Celeste Malloy and Colby Jenkins. That one was also much closer than I expected. It's going to a recount because it's within about 300 votes. I don't have the number off the top of my head, but Senator Mike Lee got involved in that and endorsed Jenkins late and almost got him to the win at convention, forced it into a primary where it was where Malloy hung on by her fingernails.
That was a fascinating result too, because Celeste Malloy was endorsed by Donald Trump, so you essentially saw an endorsement between from Donald Trump and one from Mike Lee going head to head. And Celeste Malloy, in this special election last year, was seen as a candidate who was loved by the rural parts of the district because of her work as an attorney for different counties in the district, and because her entire career has been based on work around public lands, and she would like to not see the government have as much land as it does. And so it was interesting to see her not perform as well as she did in the special election, especially after just being in office for 6 months.
Yeah, and it's just going to come down to a handful. It came down to a handful of votes that will keep her in office, because it's very hard to conceive an era, a world in which a Democrat can win in one of these 4 seats, calling back to the suit over the gerrymandered congressional districts. That's Emily Anderson Stern. Again, read her story about Spencer Cox and the head of the Utah National Guard. It's at sltrib.com. It is a tremendous piece of work. You can find her on socials, the platform formerly known as Twitter, at Emily Ree Anderson. It's Emily R.E. Anderson. We will talk to you soon. Coming up next, we'll talk with Ben Phillips of the Campaign Legal Center. They were one of the plaintiffs in the recent Utah Supreme Court decision on the anti-gerrymandering citizens initiative. We'll talk about that decision and what it means coming up.
Hi, my name is Ben Phillips. I'm legal counsel for voting rights and redistricting with the Campaign Legal Center. And I was one of the attorneys representing the plaintiffs in this case.
Ben, thank you so much for joining me today on the podcast. This was a massive decision, massive opinion by the Utah Supreme Court, and there's a lot of people who really aren't understanding exactly what went down, how it works. So in a very, in basic terms, so people can understand, what's the TLDR on this case? Talk about how we got here, what the challenge was, and then we can get into the decision and what that means going forward.
Absolutely. I mean, at bottom, what this case is about is the fundamental right of Utah voters to have a meaningful say in how their government is structured, and that the legislature can't just ignore the voters. So that's what this case is about. But to understand it, we really have to go back to 2018, because the Utah legislature had passed over the years a series of gerrymandered legislative and congressional maps. And in 2018, the voters, after gathering signatures in this statewide campaign, passed Proposition 4, which is known as the Better Boundaries proposition. And that established an independent commission to do the line drawing and a series of criteria, including no partisan gerrymandering. And this was a big deal. This was the voters of Utah saying, we want fair redistricting. Then in 2020, the legislature just repealed Proposition 4 and put in place their own extreme partisan gerrymander of the congressional districts. And so then that's sort of the background. Then our clients, the League of Women Voters, Mormon Women for Ethical Government, and several individual voters came in and filed a lawsuit challenging this, saying that this infringes on the fundamental rights of Utah voters. And that's what this case was about.
And I've been through a number of redistricting cycles. I do remember one year, I believe it was possibly 2011, the first year. Actually, it was before that. It was during the 2001 cycle when the legislature passed a map, and that's when Utah only had 3 congressional districts at the time, but the Wall Street Journal editorial board, hardly a paragon of progressive thought, came out and said that one of the districts was the most gerrymandered district in the entire country. So this has been a problem in Utah politics, or an issue in Utah politics, for a long time. Okay, so we've gotten the backstory, and so the legislature passed those new maps in 2021. And did not use any of the recommendations from the Independent Redistricting Commission, which they turned into an advisory board rather than having statutory authority. There was a lawsuit, and then last week the Utah Supreme Court issued a ruling basically saying that the legislature does not get the final say when it comes to ballot initiatives that reform government. Am I describing?
That's exactly right. That's exactly right. The court said that the Utah Constitution protects the right of the people to pass a ballot initiative that alters or reforms their government, and that if the legislature is able to just come in and repeal that, that would make that right kind of meaningless. And so when the legislature takes an action that infringes on that right of the people by impairing the whole idea of the government initiative, the legislature has to meet a very high standard called strict scrutiny when they do that.
And that means that if they want to change it, they also have to have a narrow and limited interest in changing that ballot initiative. They can't simply go in, and the reason can't be because we don't like it, correct?
That's right. And in this case, they didn't even really provide a reason. They just repealed Proposition 4 and put in place their own extreme gerrymander that sliced up Salt Lake County. And the court is saying, no, when the people exercise this fundamental right, any action that the legislature takes to impair that reform, they have to provide what you just described, a compelling government interest and an action that is narrowly tailored to address it. And it's pretty clear that repealing the whole thing is not narrowly tailored.
So explain what happens now, because it does not mean that Prop 4, which is what the proposition was, it doesn't mean that goes back into effect. We're heading down to a lower court where they're going to decide what?
Yeah, so it goes back to the district court for the district court to now apply this ruling. And so the question that the district court will have is they will now look at what the legislature did with this repeal and apply strict scrutiny and say, did the legislature have a compelling government interest when they repealed Prop 4, and was the action that they took narrowly tailored? And like I said, it's pretty hard to imagine what the compelling government interest in an extreme gerrymander is. And even if there is a compelling government interest, how is repealing the entirety of Prop 4 and putting in place SB 200 instead, that's not narrowly tailored. So that's the next step. And then if the district court rules in favor of the plaintiffs on this, then that would mean Proposition 4, with all of its criteria about neutral redistricting, no gerrymandering, those would all be back in effect.
And there's the possibility that the court could then throw out the maps. But would that only mean the lawsuit was over the congressional maps, but could that also mean that they would throw out the legislative maps and state school boards, which are also drawn by the legislature, ignoring what the independent commission put and actually proposed when they did the redistricting?
It could, because like you said, though the legislative map and other redistricting was also not done in accordance with Proposition 4. So if Proposition 4 is back in effect, then all of the maps that were drawn ignoring those criteria would be invalid. And
which would completely upend a lot of stuff here in Utah politics. That would have a major impact. One of the things, and I'm not asking you to argue your case here on the podcast, that would be improper, but one of the things that I know lawmakers are going to say, because they said this when they were changing Prop 4 in favor of SB 200, is that the Utah Constitution says that the legislature is in charge of redistricting. But I'm guessing that you have an argument saying that these two things are not mutually exclusive, that there is a way for these principles to be in effect while still having the legislature be in charge of it, right?
Yeah, because even under Proposition 4, the legislature still can have the sort of final say on the map. It's just if they choose not to adopt one of the neutral maps that the independent commission drew, the legislature has to provide a written report explaining why their map better complies with the neutral criteria in law. And here, the legislature didn't do that at all. They didn't really provide much of an excuse whatsoever. But yeah, that doesn't Proposition 4 doesn't take redistricting entirely away from the legislature or anything. It just says whoever's doing redistricting in Utah has to do it in a way that's fair and neutral and transparent.
How does this case compare with some of the other redistricting cases the Campaign Legal Center has been involved with? I'm just trying to get a sense of, how much of a gerrymander or how out of the norm this would be, because the Supreme Court issued a ruling, I think it was 2 or 3 years ago, saying that the legislature saying that they would no longer handle gerrymandering cases other than racial gerrymanders, and they may not do that anymore. So I'm just curious where you think that Utah ranks in this, or at least where Utah fits into states that gerrymander, which is a problem when you have lawmakers choosing their constituents rather than constituents choosing their lawmakers.
Exactly. I mean, that's the fundamental problem with gerrymandering. Is in democracy, voters should be selecting who their representatives are, not representatives drawing lines to select their voters. And as you said, after the U.S. Supreme Court in Rucho versus Common Cause said that partisan gerrymandering was not something that federal courts were going to look at, states all across the country took it upon themselves, and voters in those states took it upon themselves to prevent partisan gerrymandering under state law. And Proposition 4, the Better Boundaries effort, was a great example of that. I think what's really interesting about this case and about Utah in particular is this provision of the Utah Constitution that says that the voters have the right to alter and reform their government, and that they can do it through the initiative process. And that's what happened here. And so some states don't have that provision, but that one, and that was the sort of whole basis of this decision by the Utah Supreme Court, that makes this one a really interesting case, because in Utah, in sort of the history of Utah, and the court goes into great detail about the history of the state, going back in the context of the United States and back to the Enlightenment and ancient Greece and everything, that the right of the people is really kind of sacrosanct and fundamental. And that's one of the things that made this case really interesting.
And there's also a provision in the Utah Constitution that says all political power is inherent in the people. The people hold all the power, or that's where it comes from, which I also think is a unique provision and underpins a lot of what the Utah Supreme Court says. One of the criticisms of the ruling, and I've seen this from lawmakers, and you can choose to comment on this or not, but one of the criticisms I've seen is that they're worried about Utah becoming like California, where you'll see a lot of ballot initiatives. California has been a very convenient boogeyman for Utah politicians for a number of years, but the legislature in recent years has made a lot of moves to make it much harder to get ballot initiatives on the ballot. Instead of paying signature collectors by the signature, they can only pay them hourly. They have to give the person who signs it the opportunity to read the entire initiative and then confirm that they understand what they are signing for. And then even if they qualify, there's an opportunity to contact voters to have them take it off of the ballot. So it's already a really high bar to get something on the ballot right now. Your thoughts on some of those hurdles that we've seen here, and I know they're doing the same thing in other states as well.
Yeah, I think the legislature shouldn't be so afraid of what the people think and want. Proposition 4 was such a great example of Utah citizens organizing across the state, across lines of party difference and everything else, to really meet those extremely high bars and all those hurdles that you just described, and expressed what they wanted. The voters of Utah said, we want fair and independent redistricting. And I mean, this is an effort led by and for Utah voters. And I think the fact that the legislature wants to further restrict the ability of voters to do this, I think that just goes to show how important this provision of the Utah Constitution that says, well, no, actually, in the interplay between the people and their representatives, the people have the right to alter and reform their government. And that's why this decision is so important.
Okay, so
this decision also,
please.
So the court also said, if the legislature wants to amend initiative to make it more administratable or make technical fixes, or that's totally fine. That they can do that. And this decision only focuses on initiatives that are specifically about altering and reforming the government. And so the ability of the legislature to govern and do their job is alive and well. It's just that the court's saying they can't totally ignore the people while they're doing that.
Okay, so map out what's next. When do you anticipate that we'll be heading back to the lower court to hear arguments on this? Do you have any sort of a timeline that we might be looking at here?
I'm reluctant to speculate about what courts do and to try and predict, but I think we should be back at the district court relatively soon, I think. There's a series of steps that will need to happen before ultimately there would be a new map. But our hope is that by 2026, which is the next congressional elections, that there would be a new map. I don't want to predict, a lot of things can happen between now and then, but that's the ultimate timeline I think that would be.
Ben, it's been informative. I really appreciate your time. Thanks for coming on.
Thanks for having me.
Let's wrap up this inaugural podcast with a little news that happened earlier today. I'm recording this on Thursday afternoon, and it has to do with Republican gubernatorial candidate Phil Lyman's efforts to somehow cast doubt on his loss in the Republican primary to Spencer Cox. His latest efforts involve casting doubt on the validity of the signatures that Cox submitted to qualify for the primary ballot. He needed 28,000 signatures in order to do that. He did that pretty easily, paid a signature gathering company to do that. You'll remember that Phil Lyman won the vote at the Utah Republican Party convention in April. He got about 2,500 votes from delegates to defeat Cox at the convention. But then in the primary, Cox got over 232,000 votes from registered Republican voters to defeat Lyman in that election. Well, Lyman is pushing really hard to get access to the signature packets that Cox turned in to qualify for the ballot. And Lyman is suggesting that those signatures may not be legitimate. And what he wants to do is they're hoping to be able to disqualify enough of those signatures, throw enough of those signatures out that Cox drops below that 28,000 signature threshold, and then he no longer would have qualified for the primary ballot. He's kicked off the ballot after Lyman challenges the results, and then Lyman takes his place as the Republican nominee in November. That's what they're trying to do. Lyman admitted that that's what they want to accomplish. And two things happened today on Thursday that I'd like to discuss briefly. First, there was a hearing at the Utah State Records Committee. Now, this one was not about Cox's signature packets at all. It was about the signature packets that were turned in by Republican State Senator Don Ipson for his reelection campaign. And he had a lot of those signatures invalidated. They were thrown out because they did not match the ones that they had on file. In fact, so many of them were thrown out that he did not qualify for the primary using signatures. What he did instead was able to go to the convention. He got enough support from delegates to qualify for the primary, and then he won the primary election, defeating former Utah State Representative Chad Benyon, which happened last month. Well, the number of signatures that were thrown out from Ipson's batch raised some eyebrows, and so there was an open records request made by another person not affiliated with Lyman's campaign, hoping to get access to Ipson's signature packets. And that was made under Utah's open records law, which is known as the Government Records Access Management Act, or GRAMA, and so he wanted to get a hold of Ipson's signatures. Well, that was denied, And so that denial was appealed to the State Records Committee, and that hearing was this afternoon. And Lyman's campaign interceded in that appeal. They were hoping to piggyback off of that in order to get access to Ipsen's signature packets. And the reason why Lyman got involved in this is Ipsen and Cox used the same signature gathering company, which is known as Gathering Inc. And what happened was that the initial records request, the open records request, was denied because the Washington County attorney said they had opened an investigation into the signatures that had been submitted on Ipsen's behalf because there was something that didn't make sense to them or something that was a little bit amiss. So they were investigating that. And we found out today that there was about 30 to 60 signatures that are under investigation. Now, I need to be clear here. Gathering.com, the company itself, is not under investigation. Lyman's campaign has repeatedly said that Gathering is under investigation, and that is not true at all. What the investigation is focusing on one of the independent contractors that Gathering hired to collect signatures on Ipsen's behalf in Washington County. So what Lyman's campaign, at least their theory is that since Ipsen and Cox use the same signature gathering company, it's possible that some of the signatures that were rejected from Ipsen's packets were validated for Cox. And the reason they say that is because those signatures were validated in two separate locations. Ipsen signatures were validated in Washington County, because that's where his election was. But Cox was a statewide race, so they sent his signature packets to Davis County to be validated. And they want to take a look and see if any of the signatures that were thrown out for Ipsen were actually included on Cox's signature packets. And again, if they can disqualify 500 or 600 signatures, then they think that they have a chance of disqualifying Cox from the November ballot. So the State Records Committee voted against giving access to Lyman's campaign. His supporters who were there, Lyman spent a couple of weeks encouraging his supporters to show up, and they did, and they reacted very angrily when that request was denied. One person got up yelling about a banana republic. Another person yelled at the committee that the decision had, and I'm quoting here, the aroma of mendacity, which objectively is a pretty great line, no matter what context it's in. Aroma of mendacity is fantastic. In fact, if I hadn't already picked a name for this podcast, Aroma of Mendacity would be right up there with the top possibilities. Anyway, so, and you can read all about that in my story. So that was the first thing that happened today. The second thing that happened was a hearing in 3rd District Court in West Jordan. Lyman's campaign filed their own open records request trying to get a hold of Cox's signature packets. That was denied, but in order to expedite their appeal of that denial, they've gone to court. And they want to try to get a hold of those signature packets. The problem for Lyman, they were asking for a temporary restraining order that would force the state to hand over those signatures, or at least give them access to the signature packets and hand over the information of all of the 28,000 voters who signed those packets for Cox, because they want to conduct their own investigation and verify whether those signatures were valid. But here's the problem. When a person goes to vote, when a person goes to register to vote here in Utah, they can opt to have their information marked as private. And that means that their information, their name, address, birth date, voting history, all that stuff cannot be disclosed to the public. I could roll up to the Lieutenant Governor's office right now, and if I wanted to pay about $1,000, I can get something called the voter file, which has all the personal information of the registered voters in the state, but not those that are marked private. That's not included. Campaigns, candidates can get access to those private records for campaign purposes. But normally you cannot reveal that information. It's not subject to open records law. And I saw one estimate that about 40% of Utah voters have had their records marked as private. So that's one of the problems. There are also records that are marked as withheld, and those cannot be disclosed under any circumstances at all. Think domestic violence victims or situations where there may be a restraining order or whatever. Lyman's campaign is arguing that they want to inspect Cox's signatures, but then they want a copy of all of the information for every voter that signed those packets, including the voter records that are marked as private or withheld. So that's that's the big part of today's court hearing. And they think that their efforts to try and verify Cox's signatures override any privacy concerns, because they're arguing if Cox did not appear on the ballot legitimately, then that should override any privacy concerns. So the judge heard arguments on that today. He did not release an opinion. Lyman's campaign at first argued they wanted those records by Monday, July 22nd, which is the reason for the emergency restraining order, but because that's the day that the statewide primary results are certified. But after they were pressed a little bit by the judge, they admitted the drop dead date for them is actually September 6th, because that's the last day that you can add someone to the ballot. But they want to have some time to, if they're able to get these records, they want to have some time to conduct their own investigation, and then if they find irregularities, challenge those signatures and potentially throw Cox off the ballot. So that's the heart of what happened this afternoon. Now, attorneys for the state argued that you cannot use Utah's open records law to conduct an ad hoc audit of the signature packets after the fact. They say that's just not allowed, that you cannot use the open records law to do that. And they also said the real drop dead date was April 15th, when the signature gathering a window closed. So we'll see what the judge rules in that. It should be coming in short order, so stay tuned for that. But that's just part of Lyman's ongoing efforts to deny that he lost the election to Spencer Cox, and to somehow overturn those results and possibly get Spencer Cox kicked off the ballot in November. Okay, so that's episode number 1. It's in the books. Thank you so much for listening. Hit that subscribe button if you have not yet. If someone forwarded this podcast to you, I'd love it if you subscribed. Or if you know someone who might enjoy the show, send it along to them. And subscribe whenever you can, wherever you get your podcast. Most importantly, if you could leave us a rating and review, that really helps. Podcasts are slaves to the algorithm, and that's the best way for platforms to suggest this podcast to new listeners. So that will help us expand our audience. So if you could leave a rating and review, that would be great. If you have a question or a comment, you can always reach me on my social media. I'm on all the major platforms, and my handle is Shot Happens, SCHOTTHAPPENS. You can leave me a comment or a question there, but you can also leave me a voicemail. I've set up a voicemail number where you can leave your comment, a question, a guest suggestion, someone you want to hear from on the podcast. And all you have to do is call 385-236 3205. That's 385-236-3205. Leave a voicemail there, and we may use it on an upcoming episode. Once again, thank you so much for listening to this first episode of This Week in Utah Politics. I'm Brian Schott.